May it please you, my Lord, in this matter I appear with my learned friend, Mr. Marcus Staff, on behalf of the appellant.
Yes.
And my learned friends, Lord Faulkner and Mr. Edward Levy, appear on behalf of the respondent. My Lord, may I give a brief roadmap as to how, with the court's permission, or the board's permission, I would wish to address the issues.
Thank you.
Firstly, a brief introduction, then to take the board through the facts, then to deal with the issue of unauthorized investment, then unauthorized borrowing, then non-disclosure, then causation.
You're going a bit fast for me, Mr.
I
Brown.
am so sorry, my Lord.
Unauthorized investment. 4, I think, was unauthorized borrowing.
5, non-disclosure.
Yeah.
6, causation and loss.
Yeah.
And 7, damages. Also, of course, subject to the board's pleasure, my timing would be to deal with items 1 to 5 before the short adjournment and items 6 and 7 after the short adjournment.
That sounds very convenient, Mr. Black.
Well, I hope...
But so far as facts are concerned, we've spent a lot of time reading the voluminous papers in this case, and I think you can take it that we're pretty au fait with the facts. So Section 2 can be taken perhaps fairly briefly on the basis that if you refer to something that any of us feels we don't quite understand in terms of fact, we'll ask you.
I'm grateful for that. My Lord, I would submit there are 1 or 2 factual issues that don't necessarily shine out from a reading of the papers that those at the bar are rather more familiar with. For example, looking at some of the allocation tables and so on.
That would be helpful.
They take
Mr. Black.
a bit of understanding, some of them.
We'll leave it to you, Mr. Black.
I'm obliged for that, my Lord. May I begin then, as I said, with a very brief introduction, and to take immediately, if I may say, something that I suspect would be the reaction of any second appellate tribunal in a case like this, which is likely to say to itself that this is simply a case of a disappointed investor who lost a lot of money in the crash of 2008, and somebody who has the will and the resources to pursue his bankers in the hope that he might recover some of those losses after having had the benefit of a 10-day trial, 4 days in the Court of Appeal, and now able to bring it before this board. We would respectfully submit that that temptation should be resisted as an unfair characterization of this appellant's case, because an extraordinary feature of this case is a nearly 4-year delay between the arguments before the Court of Appeal and the Court of Appeal's judgment. Now, we of course accept that delay per se may not give rise to injustice, but we say that we can demonstrate in this case that it did. And indeed, the most striking feature is that on the 4th day of the appeal, my learned friends raised a new point that required a respondent's notice, namely that the Grand Court's judgment could be supported on other grounds. This is what we've called the new contention in our submissions. There is no mention of the new contention in the Court of Appeal's judgment. Even if the Court of Appeal were minded not to dismiss the point, they should, in our respectful submission, at least indicate that they'd considered it.
Mr. Black, obviously a 4-year delay is quite astonishing.
Yes.
And I think all we want to know is what explanation was given to the parties about it.
There wasn't. We understand that the president of the Court of Appeal was ill at some point. We believe about 3 years in, but we're not terribly sure.
Very well.
Well, it's embarrassing to any court to have to deal with that, but what's the consequence? Why does it make it any worse for you?
Well, my Lord...
and secondly, why did the new contention arise on the view of the case that the Court of Appeal took?
My Lord, first of all, the new contention is the most striking point that hasn't been dealt with in the judgment. There are others which I will advert to, and indeed 2 points. Firstly, we have undertaken a quite detailed analysis, paragraph by paragraph, of the Court of Appeal's judgment, and there is no indication that the judgment has taken account of any oral argument on any issue before this board. It's a lengthy analysis, and I'm very happy to share it with the board, perhaps at a convenient moment when the board, and indeed my learned friends, so that they can have a look at it. Equally, during the course of argument, there were a number of matters, again, to which I will advert, that the Court of Appeal expressed some views, one of which led to the new contention, which I'll develop in due course, because the Court of Appeal said that it was very hard to reconcile the idea of Blossom being a mere administrative step when it is a company and one is buying shares in the company. And my learned friend, as we'll see, said, well, I have perhaps a better argument than that, and the new contention arose in those circumstances. And again, we have undertaken an analysis in schedule form for our own purposes of the matters raised by the Court of Appeal which were not subsequently addressed, and we're again happy to share that with our learned friends perhaps at the end of the day, and give copies to the board if my learned friends are seeing it. But what we do say is the net result of all that is that the appellant has essentially been deprived of an effective first appeal. If we are right, and essentially the Court of Appeal overlooked or forgot the oral arguments that were made to it some 4 years earlier, then we say that this may not be regarded, or ought not to be regarded, as a case of concurrent findings. And in fact, the board rather finds itself in the position of the first appellate court rather than the second appellate court. But in answer to my Lord's friend, my Lord's question, I will, I hope, develop the areas where we say that there has been a particular impact on the case. So the Grand Court structured its judgment on issue-by-issue basis. This meant, in our submission, that the interaction between the breach, in particular, of clauses A of the SPA and the authorised borrowing on the one hand, and the breach of clause 4, the non-disclosure, on the other hand, was lost. We say that it's only if one approaches the case on a holistic basis, it can be seen that clause F4, the breach of clause F4, concealed the breaches of clause A and the unauthorized borrowing. And indeed, coming immediately to one of the issues that I just flagged up, it's right to say that the Court of Appeal itself was troubled that the judge below did not consider the combination of the breaches, the other breaches, and the breach of clause F4, and whether indeed it would lead Mr. Al-Sadik to bail out. If I can just very briefly take you to a reference to that, I'm going to try and use the electronic bundle, if I may. It's at page 2375 of the electronic bundle. For those of the board who are not using electronic bundle, it is at tab 38 in volume 6. But this is part of the transcript of the hearing before the Court of Appeal. And the president of the Court of Appeal said that he, the judge below, didn't address what was the position.
I'm sorry, record volume 6, what page?
It's 2375, sorry, not record volume 6, it's the court volume 6, 2375. It's that they have
records documents.
All record documents, volume 6, tab 38.
Tab 38, I was obliged.
Thank you. 2376.
75.
2375.
Yes, fine. Thank you.
So, transcript, page 79, right-hand side. The learned president said the judge didn't address what was the position if you couple the breach of non-reporting with the breach of reporting with breach of mandate. My learned friend says yes. And then the judge says he didn't consider that because he's finding he didn't need to. I'm not sure in my mind when you get then there was a transcript reference, the judge has in mind the question of whether they would have allocated 50% each to the two funds is only relevant on the assumption that Mr. Sadik wouldn't have bailed out. And then it finishes just at the bottom, the top of the next page. He doesn't appear to address the point, that's what's troubling me. So this is one of the issues that we say that at least at that stage, troubled the Court of Appeal, and we say it is an important feature of the case, because the appellant was not only told that no leverage at all was applied to his portfolio, as we'll see from the reports that were given to him, but he was also positively misled about the structure and application.
No leverage was applied, or he was not told that leverage was applied?
He was not told that leverage was applied. When one has a look...
Well, there's a big difference between those two things. You're not suggesting that he was positively told there is no leverage, are you?
Oh, yes, my lord. You will see that when you look at...
Very well.
When you actually look at... That's why I want to take you to the allocation documents, because you will see that in terms. At least leverage, I say, at portfolio level. We differentiate between portfolio level and fund level. It is accepted completely that the appellant, as an investor who understood hedge funds, knew that individual hedge funds use leverage as part of their investment strategy. So, but he was not told, and it was disguised from him, that leverage was used at the portfolio level. And he was therefore unable, or rather Mr. Zaidi, his investment manager, was unable on his behalf to monitor his investment and either exercise his right of redemption or indeed discover that the mandate had been breached. So with that brief introduction, may I turn to the chronology. And so in January of 2008, the board will be aware that there was an investment proposal, and I won't take you to that in deference to my Lord's suggestion that the board has already read much of the documents. But the investment proposal certainly indicated a proposed investment in funds that use leverage. There's no question about that. So the appellant paid over $500 million dirhams to Investcorp on the 28th of February to invest on the terms of a mandate, which was then under negotiation. The mandate was in the form of a share purchase agreement, which was executed on the 1st of March. Negotiations were with Mr. Kironde. Mr. Kironde, in his witness statement, I won't take you to it, but it is in the record, indicated that not only was he the negotiator referring matters back to the drafting team, but he also did some drafting himself. And just for the note, that's in his witness statement at paragraphs 5.1 and 5.24, record bundle 7, pages 2594 and 2601. But what I do need to take you to is the SPA itself, and that is found in the core documents in volume 6 at tab 43, beginning at page 2481.
We've got on our desks a typed out extract. Does that come from your side?
It doesn't come from my side, no.
I see, okay.
No, I think it's been prepared internally.
I see, yes.
May I just take you through it? I won't read it because I'm sure the board again has looked at it. But if I can,
well, I don't want to mislead you.
Yes.
I don't think we've looked at this particular document. We've looked at the clauses which have been referred to repeatedly.
Yes.
In the cases and in the judgments.
Yes, and so I'm not going to reread them out to the board. In summary, there is then an investment account in the form of shallot, which invests in hedge funds or segregated accounts and hedge funds with any other hedge fund managers with whom Investcorp is invested. The investment manager could select any branded Investcorp hedge fund or hedge fund product, we say Investcorp doesn't itself, as may have been apparent, actually operate hedge funds. It invests in hedge funds managed by others and aggregates them into funds of funds, with the exception of the single manager funds, which are, of course, what they say, single managers. But something like the Diversified Strategy Fund, in fact, had 77 different managers. And so the investment manager under this mandate could select a hedge fund or a segregated account with a manager with which Investcorp had invested. There are words which are slightly problematical in which gave the Court of Appeal some pause to reflect, which is including but not limited to. We would respectfully suggest that they don't seem to add very much to the wording, because if they did, that would mean that the right to invest with any hedge fund manager is unlimited, but clearly the proviso that any other hedge fund manager has to be a hedge fund manager with whom Investcorp is invested would then be robbed of meaning. The assets of Charlotte were called assets under management, and the assets under management invested in hedge fund or segregated accounts.
So you submit that we simply ignore, but not limited to, and say that the following investments are the only investments permitted?
I do say that, my lord, yes.
Not limited to means limited to.
Well, my lord, it seems to be one of those drafting phrases put in there without very much thought as to the consequences.
Well, how do we know that?
Well, my lord, one has to look at the clause, and we say in construing the clause, my lord, in a sense, first of all, it doesn't really impact upon where we're going to go, because there were not investments with hedge fund managers other than Investcorp, and so the focus of the consideration of this clause is whether or not Blossom qualifies as an Investcorp hedge fund, and that has been the way that it has been argued. So my learned friend's submission and pleading was that it was an Investcorp hedge fund. If it isn't an Investcorp hedge fund, then it's an Investcorp hedge fund.
That was the case that he introduced on day 4 of the Court of Appeal.
Yes, my lord.
Right. But it looks like an alternative case.
Yes, the primary case is that Blossom was a mere administrative step, and that one takes the judge's analysis that, and it's something obviously I must come to on the unauthorized investment issue, that you interpret this document by reference to an overriding commercial purpose, that it is to construct a leveraged portfolio, whatever that means, and therefore you can undertake anything, the judge said, that is not effectively expressly prohibited to achieve that purpose.
Well, I think you did say in your case that Lord Falconer, in introducing the new point, had in effect abandoned the Administrative Act point. But you are abandoning that argument now, Mr. Black, and rightly so.
Abandoning the Administrative Act?
You're abandoning the argument that Lord Falconer abandoned the Administrative Act point.
Yes, I accept it, sir.
Good.
I accept it's an alternative.
I mean, I don't think it's being suggested against you that the investment priorities agreed at the end of February were, so to speak, implied terms.
No.
I think what is being said is that an investment management agreement of this kind leaves a number of things, often things that tend to change over the life of the management agreement, to be agreed from time to time between the investor and the manager, one of which is his appetite for risk, the investment principles, the asset allocation, and so on. And that would certainly be true of pretty well every investment management agreement I've ever seen. So it's not a question of implied terms, is it?
it's not a question, we would certainly say it's not a question of implied terms.
But you're
And what my Lord says, of course, highlights the necessity for the investment manager and the bank truthfully to represent to the investor the state of his investments, because otherwise he can't do all the things that my Lord has said. That his appetite to risk may change, the markets may change. The markets change very dramatically in this case. Within 10 days of signing the investment agreement, Bear Stearns was in trouble on the 14th of March. This was signed on the 4th of March, and then we know what unrolled during the rest of 2008.
But I had the impression from your printed case that you were saying that the pre-contractual discussions were irrelevant because they couldn't be treated as incorporated into the contract. Is that
My Lord, I wouldn't go. My Lord, I wouldn't go as far as that. And if I'm asked if you hold me to that, my Lord, I concede that it is part of the factual matrix within which one construes and interprets the.
So you accept that it's open to parties to a prospective management agreement to agree the investment criteria?
Of course, my Lord, yes.
Right, okay.
Moving on, just to familiarise the board with the structure. So clause B, the appellant purchases shares in Charlotte with the investment amount, so the cash becomes the first assets under management. The base currency, as we see in the second paragraph of the company, is US dollars. If I could then move forward, please, to clause D1, which is on the next page, 2482. And there it's provided that there would be entered an investment management agreement. As I think the board will be aware, that was not entered into. And I think my learned friends now accept that this was an internal document to Investcorp, and whilst the judge, I think, said twice that both parties overlooked it, my learned friend's printed case indicates that it was not something that was in the power of the appellant to overlook. And then clause D2, which figures in the reasoning, which gives the company's board the power to take any actions that the board believes necessary or desirable to effectuate the purposes of this investment. We would say that the purposes, of course, are those purposes that are found in clause A. May I then ask the board to pass on to page 2484 and clause F. Clause F1 states that the bank will be responsible for calculating the net asset value of the company. Clause 2 says it shall calculate the net asset value on a monthly basis. And then F4 on the next page, 2485, provides a monthly statement of the underlying investments will be issued as soon as practicable. And then we find the redemption rights on the next page at clause H. Essentially, Mr. Al-Sadik could redeem 1/3 during the first year on 60 days' notice and redeem the balance thereafter. And then at the bottom of the page, I, borrowing relationships, and that goes over to the next page, 2487. And this provides for borrowing for liquidity purposes, and it is common ground that the clause does not provide authority for Charlotte to borrow for investment purposes. And then just finally to complete at clause L124, page 248, the application of Cayman law. So at the end of February of 2008, the bank received Mr. Al-Sadik's $500 million dirhams, $136 million, and Charlotte was incorporated. the respondents in their pleading, and I only raise this as a background matter, it's not, as you'll see from the printed case, not a matter upon which we claim any relief, but they recognize that gave rise to a fiduciary relationship. And then on the 2nd of March, the bank decided to invest differently from the investment proposal. And the evidence was they realized they couldn't do that using their standard product, so they used an off-the-shelf Cayman company, Blossom, and on the 3rd of March 2008 negotiated with the Royal Bank of Scotland New York branch to add Blossom to an existing facility in order for Blossom to borrow money to invest in both Investcorp's Diversified Strategies Fund, DSF, and the single manager funds, the SMFs, but also a product under development called Alt Beta. Mr. Al-Sadik was not told any of this, that there had been this change.
What date did you give us for the arrangements for Blossom to?
3rd of March 2008.
Right.
Now, DSF, Diversified Strategies Fund, was an established Investcorp product. And as I said, it comprised multiple different fund managers. But RBS imposed restrictions on how Blossom could allocate its investment decisions as between DSF on the one hand, the single manager funds, which were clearly, on any view, more volatile, being single manager funds rather than a fund of funds, and the Alt Beta product, which was still in development. And those rules are summarized at page 21 of our case at footnote 57, and also in paragraph 618 of the Grand Court's judgment, which is, for the record, at page 115 of volume 1 of the core. I don't think I need to take you to the detailed allocations, but a certain amount had to be kept in DSF. There were loan-to-value restrictions, as one would generally find in such documents. So there were specific rules from this facility, which the long name for which was a master note purchase agreement, and which was amended and restated a couple of times, but it was codenamed White Ibis 3. So White Ibis 3 did impose certain rules upon how Blossom could invest.
Mr. Black, I'm sorry
Yes.
to interrupt you. Did you say that paragraph 21 of your case explained
Page
the
20.
RBS rules?
Page 21.
Page 21.
Footnote 57.
Thank you.
It's at page 2654.
Very well, thank you.
And as I say, I'm not going to take the board to these points unless they become necessary. No. It's just necessary to note that there were rules which fettered Blossom's power to invest imposed by White Ibis 3 facility. So it's not in dispute that Mr. Al-Sadik was not told the truth about the nature and purpose of Blossom or the borrowing arrangements until a year later in March of 2009. And that comes from the judgment at paragraph 7.4, which is at volume 1 of the core bundle, page 124, and is also in the statement of fact and issues. So on the 4th of March of 2008, the bank converted Mr. Al-Sadik's dirhams into around $136 million. And then Charlotte purchased shares in Blossom for $135 million. $1 million therefore remained in Charlotte. Blossom invested all of the $135 million, 79 million in DSF, and 11.2 in each of 5 single manager funds, one fund not being able to take the subscription at that time, and therefore it was delayed until April the 1st. So this was investment made without debt. But any further investments then, after this initial investment, were all made with debt. And then, as I said before, 14th of March, Bear Stearns collapsed. And we get the first report. Again, I think I don't need to take you to this one, on the 16th of April of 2008, but just for the record, it's in record volume 17, page 6690, which did not show Blossom or any underlying investments, just the value of the shares in dirhams. Then on the 1st of May, Blossom borrowed a further amount of $67.5 million and invested that in DSF and each of the 6 single manager funds.
Did you say 1st of May?
On the 1st of May, my
1st of
lord,
May.
yes.
Okay.
On the 6th of May, there was the next report, and I would like, if I may, to show that to the board. It is in the record in volume 17, and it's to be found at page 6845.
The electronic pages only seem to go up to 4465.
Yeah.
The record goes to 9201.
Right. Well, we don't seem to have electronically copied the latter half of that.
There are two electronic. There's the core bundle, and the record are both in electronic form.
Right. That may be the answer.
And
The other one.
the record has 9201 pages in it.
Right. So what was the electronic number again?
The electronic number is R6845.
Thank you.
Hedge funds program summary of investments 1st of March to the 1st of May.
It is indeed, my lord,
Yep.
yes. So this is the report. This is the report that was received on the 6th of May to the 1st of May. And all it shows at that time is an asset allocation as at the 1st of May, says Charlotte 100%. And there's no reference to Blossom, no reference to the underlying investments, no reference to, by that time, what was the borrowing. Because
It's actually wholly uninformative, isn't it?
it is wholly uninformative.
It says nothing at all.
Well, that is absolutely
Since
right.
Charlotte was the client, effectively.
Sorry?
Since Charlotte was the client, effectively.
Yes, Charlotte is exactly right. It's also right, just by way of background, that at this point in the market, there were some reservations about continuing with leverage. I just make that point because it may become relevant later on when we discuss the possibility of Mr. Al-Sadik's reactions if he was given enough opportunity, whether or not he wished to redeem or reduce his investments. And I won't take, again, the board to it in the interest of time, but in the record itself at 8389, there were some internal discussions within Investcorp. But moving on...
Mr. Blank, just coming briefly back to this document of the 1st of May.
Yes.
So are you saying the current value of holding figure, forget Charlotte,
Yes.
current value of holding figure is wrong? What
Yes.
was it exactly?
It's wrong. The actual value of the holdings, as at the 1st of May, was 135 million plus 67.5 million in borrowing. So the total is $202.5 million. This is giving a dirhams figure, but that is a dirhams figure which only represents the original 500
That's
million.
the original $500 million.
Yes.
Yes, quite.
Yes.
488 million.
Yes, so it doesn't show the borrowing at all. It doesn't show the underlying investments. But can I? Sorry, I can't take. Can we then move on, if we may, to the 1st of June? On the 1st of June, Blossom borrows again and invests another $33.9 million in DSF. and 5.6 million in each of the 6 single manager funds, making another 667 million in debt. So now we have a total of 135 equity and 135 of debt. But let us see what Mr. Al-Sadik was told, and this document is in the core bundle. And so if you'd be kind enough, please, within the core bundle, it is hard copy, volume 6, tab 45, page 2493.
No.
This is slightly more informative.
Where is it electronically, please?
It is in the core at 2493.
MS 2493.
What's the date of this document?
The date of this document is the 5th of June of 2008.
Mm-hmm. Core record 6.
Yes.
Is what you're
Core volume 6, page 2493. So here we see again the shallot.
It says blossom, doesn't it?
It now says blossom, and that's, yes, my lord, and that's extremely important. If I
Yep.
may I just wait till my Lord President has it?
Forgive me.
Yeah.
Yes.
got it.
Thank you. So here we see, again, it shows shallot, the current value of holding, portfolio return, asset allocation, and here it says Blossom IAM Limited as at 1st June, and there we see the percentage allocations within the pie chart. Now, no reference, of course, there to the borrowing or the actual values of the holdings. And Mr. Zaidi, Mr. Al-Sadik's investment manager, saw the reference to Blossom, and he called Mr. Karonde and asked him what it was. And the judge found that Mr. Karonde told him that it referred to an internal arrangement to distinguish between dirhams and US dollars. The judge found that was an incomplete explanation. There is clear evidence in the record that Mr. Karonde knew the truth. He said in his witness evidence and in cross-examination that by April he was aware that Blossom was used to provide leverage. We say that this is important. Here was the opportunity for Investcorp in the person of Mr. Karonde to tell Mr. Al-Sadik the truth. He didn't do so when it would have been natural, we say, for an honest person to do so. And we say this amounts essentially to a lie by omission. But all the judge said in relation to that was the explanation seemed to satisfy Mr. Zaidi because Blossom's functional currency was dollars and Shallot's was dirhams. And he said that at paragraph 5.12 of his judgment on page 91, line 13 of the core. We say that was an extraordinary finding because the judge was effectively saying, well, Mr. Zaidi was taken in by this lie. In fact, Mr. Zaidi, and another suggested, knew nothing about Blossom's function. And indeed, Shallot's functional currency was not dirhams. It was indeed the dollar. Only its shares were denominated in dirhams. On the 10th, moving on the 10th of June, Mr. Karonde sent fact sheets for each of the underlying investments under a covering email. Again, I needn't take you to those, but they clearly disclose, and as I said before, we don't shy away from, that individual branded hedge funds use leverage. And indeed, one of the single manager funds Silverbeck declared in its information sheet the leverage that it was using. So Mr. Zaidi wanted more information about the underlying investments. And Mr. Caronde sent him a report by email, which is the first of the allocation reports, which the judge in his judgment at paragraph 513, page 92, found to be misleading. And I need to take you to that, if I may. You will find that, again, in the full record rather than in the core, and that is at page 5904.
Which volume?
Which volume is... Sorry, my lord, if you'd be kind enough to bear with me.
15.
I'm grateful, my learned friend, thank you.
Thank you.
So this is the 26th of June email sending this allocation table. As I said, the judge found the first section to be misleading, and it was positively misleading in two material respects. First of all, while it showed the actual value converted into dirhams of the investments in hedge funds made in March and April, the figure for May is a fabricated figure because it doesn't represent the actual value. What has been done it is a notional value after deducting pro rata the debt from the values of the various hedge funds to bring it down to a value which is said to represent the net asset value, but it certainly doesn't in any sense represent the actual holdings, as appears to be the situation of the Diversified Strategies Fund and the single manager funds there. I would also ask the board at this point to note the penultimate column, which is headed cash. I mentioned before that only $135 million were invested and some cash remained in Charlotte. And that is what is represented in the cash column at the end. So then on the 1st of August...
So this document does tell your client that there are losses here.
It doesn't, no.
It doesn't.
No, it doesn't tell the losses, and it doesn't show the actual holdings in the identified funds, nor are the funds identified as being leveraged. So there was a fund called Leveraged Diversified Strategy Fund.
Well, quite.
But this just says Diversified Strategy Fund. There was also a fund called SMF Co, which was a leveraged vehicle for investing in individual single fund managers.
Mr. Black, obviously I've misread this document. I'm looking at Diversified Strategies Fund. 1st of March, 290 million. 31st of May, 243. So I say to myself, there are losses here, but I've misread it.
If you go to the end total, he's actually $1 million up on his 500.
And the complaint about the May figure is that it's a net figure rather than an actual holdings figure.
Yes, yes. And the obligation under the contract was to disclose the underlying investments. It doesn't do that. It doesn't show what the underlying investments are in our submission. So on the 1st of August 2008, Blossom borrows another 33.9 million, invests in DSF. So now the true position is that we have 169.5 million in DSF and 134.4 million in the Single Managers Fund, making a total investment of 303.9 million with 168.9 debt. So we then get another one of the reports that we've seen in the form of the pie charts, just with with the assets shown as by way of percentages, and also the reference to Blossom that we saw before. On the 1st of September, the bank borrowed another 45.2 million. So the total invested is then approximately $350 million with debt of around 214 million. And then, of course, things start going south. And on the 8th of September, the portfolio is down nearly 10%. And on the 11th, Mr. Kironde was about to send another table like the one we've just been looking at a moment ago, the allocation table. And there was a gentleman within Investcorp called Mr. Mirza, whose job it was to prepare it for him. May I just show you, whilst we're still in the record, page 6733, which is
17.
volume 17. I'm obliged to my learned friend again. So reading up from the bottom of the page on 6733 is a letter, an email from Mr. Mirza to Mr. Kironde showing the later version, by which time Mr. Al-Sadik is losing money. And he says, attached is the updated data for Charlotte. Please note the negative cash balance, which is mostly the accumulated loan interest on the leverage facility. Do you want to show this? And then Mr. Kironde's reply is, how would you show it without the cash balances? So that cash column is taken away, and that is what is sent to Mr. Zaidi. And what is sent to Mr. Zaidi is in the core bundle, and that is in volume 6 of the core bundle, tab 48, at page 2501.
250.
2501, my lord.
6.
It is described in the covering email, which is the preceding page, as an exposure report. We would say that it is precisely not that, because it doesn't show the actual exposure at all. Again, he is being told that he has certain holdings in diversified strategies and in the particular single manager fund. He's not told about the borrowing, and he's not told the actual value of his holdings. In other words, what his exposure is. Of course, we're in September now, and the next date is one which I suspect means a great deal to my Lord Briggs, the 15th of September, when Lehman Brothers entered into bankruptcy. 2 days later, on the 17th of September, Mr. Kironde met Mr. Al-Sadik and Mr. Zaidi, and the judge found that he spent 45 minutes explaining the intricacies of fund administration accounting, but he didn't explain how this accounting was done. The losses continue. 7th of October, the portfolio is down nearly 25%. And then an important thing happens in our submission. On the 31st of October of 2008, due to the value in the fall in value of the portfolio, Blossom breaches the loan-to-value restrictions in White Ibis 3 and was forced to redeem $80 million worth of its investment in the Diversified Strategies Fund. That can be found most conveniently in the agreed chronology, which is in the appeal bundle, tab 6, page 2630. I needn't take you to it. But the important thing is Mr. Al-Sadik was not told that $80 million of his investment was redeemed. And indeed, Investcorp sent no reports to Mr. Al-Sadik between October and February of 2009. The judge found that the bank realized in February 2009 that as a result of a, quote, administrative oversight, it had not complied with its obligations under clause F4. The bank didn't actually do anything as a result of that realization, and it was left to Mr. Zaidi to chase for more information. And as a result of that, he was sent a document headed Blossom IAM Limited since inception on 1st March 2008 to 31st January 2009. And the covering email described that as Charlotte's results since inception. And we see that back in the record bundle at page 6279, volume 16 or 17? Volume 16, I'm grateful. So there we have the covering email at 2679.
26th of February.
Yes,
Yeah.
And then the document itself, I think, and then the document itself is a little further on. I think you may have to change hard bundles to 17 at 6898 is the actual document itself. And this is the first document that discloses any debt. Because you will see when you find it that it is in 3 sections. The first one is underlying manager performance in percentage terms. And the second one is headed allocation based on total equity and debt. And then at the bottom is approximate performance allocation.
Attribution.
I'm so sorry, my lord, attribution. And the judge did say that he thought at paragraph 516 of his judgment that Mr. Al-Sadik could see the effect of equity, of leverage on his portfolio. We regrettably can't decipher that, but if it's important, no doubt our learned friends will be able to help with that. But what the document didn't explain was what Blossom was, or give the actual values of the underlying investments, or disclose the amount of the debt or interest. But what the document did do is it prompted Mr. Zaidi to ask for the investment management agreement that you will recollect the SPA mandated ought to have been entered into. But of course, Investcorp had not actually got round to executing such an agreement. So instead of telling Mr. Al-Sadik about the omission, it immediately arranged for one to be drafted, signed, and backdated to the 4th of March of 2008. At the same time, Investcorp was preparing a further table that would finally show the level of leverage applied to Mr. Al-Sadik's investment and the manner in which it was carried out. And again, its preparation fell to Mr. Mirza. Again, he sent an internal email, which you will find at page 6285, which is in volume 16 of the record. And here he sends it to the team. He said, please attach the summary. All amounts are in dirhams. We show the total amount invested in each fund, debt and equity, show the aggregate amount. We also show debt equity ratio. He will see the total leverage amount and will not be happy. The IMA is being signed today/early tomorrow. If you could then turn on, please, to page 6289. We see an email from a gentleman called Mr. Tanner. Now, Mr. Tanner was the most senior man in the placement and relationship management team at Investcorp. And seeing that email, he said, please delete this email from all of your systems. I do not like paragraph 2. which he said in evidence meant reference to the IMA being signed today or tomorrow. On the 2nd of March, the bank sent Mr. Al-Sadik the new, what it called, decomposition statement, which is in bundle 17 of the record at page 6748. And one sees finally that one can see the full effect of the leverage, showing, as Mr. Mirza said, the debt-to-equity ratio, other liabilities, total equity, and so on, in the final box on the right-hand side.
Could you give me that page number again?
Yes, of course, my lord. It is 6748.
Thank you. In the record.
In the record, my lord.
What date do we put on this?
This document,
goes up to the 31st.
2nd of March 2009.
Very well.
So this is the revelation of the true position that the judge, in his judgment, and is agreed, is the first revelation of the true position in March 2009. Mr. Karonde, on the 8th of March, sent the investment management agreement to Mr. Zaidi, saying that it was between Charlotte, the company that actually has the US dollar investments, and the investment manager. And we will see the investment management agreement itself in the core bundle at tab 50 at page 2503.
Do you mean core record documents?
It is core, yes. Sorry, I can tell you, I'm so grateful. Thank you. Thank you very much. Volume 6, tab 50, 2503.
Thank you.
Just 3 points on it. You will see in the second line, it is dated effective as of March 4th, 2008. You will see when you go down to subclause B under section 1, the manager is, by this document, authorized to leverage the investment assets in such amounts with such banks and on such terms as the manager shall determine in its sole discretion. And then on the next page, there is a slightly more complicated clause under section 3, authority of the manager. And if one goes down to C, the manager is given authority to undertake, negotiate, and complete any borrowings for the account of the company from any securities broker, and so on.
And then it's signed.
It's signed
on
by
2508,
yes,
as of the date set forth above.
Yes, indeed, and indeed signed largely by the same gentleman on behalf of all of the parties. Mr. Rajab signs on behalf of Charlotte, the second signature for Charlotte, but he signs on behalf of Investcorp Bank and on behalf of the investment manager. The use that's made of that document is then a letter sent by Mr. Karonde, which he drafted and co-signed, and he sent that. It's the next tab in the core, tab 51 in bundle 6, page 2509. And we see, first of all, that he responds to Mr. Al-Sadik's query about the 25% limit on borrowing that we saw in Clause I for liquidity purposes. In the third paragraph, then, he tells Mr. Al-Sadik what a leverage is, And then in the fourth paragraph, in our discussions and presentations to you prior to setting out the portfolio, we made it clear that to achieve the returns you wished for, it was anticipated we would introduce leverage to the portfolio. This is provided for in Section 1B of the Investcorp Hedge Funds Management Agreement, and he cites that. And then in the next paragraph, he says, there is no mention in the SPA of a need on our part to report leverage. And in the final paragraph on the next page, he says that, in fact, we've been exceeding our obligations in reporting to you. The judge found the letter to be deceitful in two respects. And the reference is at paragraph 519 of his judgment, page 97 of the core bundle. First of all, he found it deceitful because Investcorp did not inform Mr. Al-Sadik that the IMA had just only been executed. And secondly, that Investcorp relied upon Section 1B, which could not have retrospective effect. And so just to finish the chronology before I come to the legal submissions, in September of 2009, the bank caused the accounts of Blossom to be audited by Ernst & Young. We've annexed those accounts to our printed case. And it is notable, we say, that Blossom is referred to as a fund in those accounts. And then finally, we come to November 2009, and can I take you to page 2529 in the core bundle. This is a letter from those instructing me, Messrs. Clyde & Co., of the 24th of November. And in particular, on the second page, Mr. Al-Sadik exercises a right of rescission that he says he has for deceitful non-disclosure.
I think I heard your page number wrong. Can you give it to me?
I'm so sorry, my lord. 2529.
Thank you, I did. Yeah.
May I then move on to my subheading of unauthorized investment and breach of Clause A. And obviously a lot of these submissions have been reduced to writing, so I will not tire the board too much on that, but it is our submission that the judge's approach reversed the process of contractual construction. That he divined what he thought was the commercial purpose of the transaction and then made the interpretation of the contract fit that. The judge did not, in our respectful submission, sufficiently focus upon the language of Clause A, and that he went too far in his understanding, perhaps, of the use of the factual matrix that he derived from Lord Hoffman's speech in Investors' Compensation and the judgment of the board in the Attorney General and Belize. Because in his view, ultimately, Investcorp were permitted to do anything in order to construct a leveraged portfolio not expressly prohibited. And he concluded that purchasing shares in Blossom was a mere administrative step that did not constitute an investment, because we say he started from the premise that the sole purpose was to construct the leveraged portfolio, and he would, as he said, expect that to be done through a wholly owned subsidiary incorporated especially for that purpose. He said that at paragraph 4.2 of his judgment. And indeed, he could not, on his own reasoning, find that Blossom was an investment, because he held correctly in our respectful submission that Blossom self-evidently was not a hedge fund, and it would therefore follow that Blossom would not be an authorized investment under the share purchase agreement. The Court of Appeal identified the difficulty with this approach, but it didn't figure in its judgment. The Court of Appeal identified that it's difficult to characterize the purchase of shares in a company as merely a transfer of funds, and indeed said that it felt the judge had, to quote, and we put this in our case at paragraph 30, a fairly cavalier view about separate corporate personality.
That's in the judgment, is it?
No, that was something that fell from the court during
Yes.
And did not figure in the judgment. But we would submit...
You do, in your case, refer quite a bit to what was said in the course of argument.
We do.
And, I mean, there is a danger about our looking at that, because judges can have second thoughts, Mr. Black.
I accept, not only can they have second thoughts, but they will play devil's advocate and clearly test the submission an advocate is making. But couple that with our analysis that there is no evidence of any recognition of the oral argument before the Court of Appeal. And you have, in our submission, where I started, the problem that Mr. Sadik has not been given the benefit, we would say, then of the hearing before the Court of Appeal. It's as if it were just decided on the written submissions, because that's all the judgment expressed. And that's perhaps what we say is the mischief of the 4 years delay in this case. Delay itself per se, we accept, may or may not give rise to injustice, but there is injustice in this case, we say, because it would appear that the Court of Appeal forgot or overlooked the oral arguments. They didn't refer, indeed, to written arguments made post-hearing. They asked for further written submissions and didn't refer to those either.
Well, you will have to be specific, because, I mean, we've read at length the judgment of Sir John.
Yes.
It is laborious. It is punctilious. It deals with it appears to deal with every argument on either side, and every conclusion about every argument on either side, going through for 151 pages.
Yes.
So you will have to make good your point that there were important arguments ventilated orally that really should have found their way into the written disposal.
And that's where I'm at the moment in my submission.
Thank you.
He must have had his own notes. Was it a case where the arguments were transcribed or not?
There was a transcription.
Was there a contemporaneous note?
Yes, there was a transcript of the...
So when he went away, admittedly rather a long time later to write the judgment, he'd got a transcript of the...
Yes, my lord.
Right, thank you.
My lord, we would submit that unless and until one construes the SPA and so as to ascertain what is or is not an investment under the SPA, it's not possible to determine whether the purchase of shares by Charlotte in Blossom would or would not qualify as an investment. And we say that it's not, unless and until the SPA is construed, it's not possible to ascertain whether Investcorp was authorized to do under the mandate what is described as an administrative step or otherwise. If it's an administrative step and it's outside the mandate, that doesn't bring it within the mandate purely by being an administrative step. And so we say that the judge and the Court of Appeal's endorsement of what he did was started at the wrong place. The parties negotiated a detailed SPA, and he should have started with that. And it's interesting that the judge spent more time in his judgment, when you read it, on construing the investment proposal than he did actually on the SPA itself. Then coming to his conclusion that the purpose of the mandate was to establish what he called a leveraged portfolio, which rather begs the question what that means, whether it means a portfolio leveraged at what we call portfolio or first layer, or leveraged at second layer or fund level.
Why does that matter?
It matters because, and I'll come to the argument, my learned friends say it doesn't matter because there is economic equivalence between the two. We say that's wrong. And I believe I can show to the board that there is not economic equivalence. There are very, very important differences.
But are you contending that there was a specific agreement as to the way in which the leveraging should be carried out?
No, I'm not. What I'm saying...
Well, why does it matter what method was used?
My lord, it matters because, for example, if Mr. Sadik invested in a fund which leveraged, so there is a fund called LDSF.
Yes.
And that I would happily concede was a hedge fund product and within the SPA.
Right.
LDSF has an information sheet. It publishes its results. You know what level of leverage you are getting when you invest in LDSF. You can see, and of course it's important for this investor, he has a right of redemption. But if you are not told what the level of leverage is, but you are just told the net value.
Well, is the difference between first or second level leveraging, as you submit, simply a matter of disclosure, or is it an economic difference in the sense that the actual result of the investment process is liable to be different?
It is possible for the economic effects to be the same. They weren't in this case, but it is possible.
But there's nothing inherent in the use of first rather than second level leveraging that affects the economic consequences. I can see your point that it may have been different in this case, but that's not something that is inherent in the choice of first level leveraging as opposed to second level.
It is mathematically possible to get the same result in two ways. But in this case, there were very, very significant differences, particularly by the use of white ibis. Leaving aside transparency, transparency is the main issue. You can't see and monitor your investment if you don't use something like LDSF and use the administrative route that is suggested. But there are very significant that I want to run through. There are about 7, in fact, I'm afraid, that I need to go through that show that the economic equivalence argument does not apply in this case. I accept, my lord, as a matter of theoretically, with respect, your lordship is, of course, absolutely right. You can achieve it, but it's fact sensitive, and the facts are different in this case.
The judge found, didn't he, that there was no industry jargon that separated out what we, in this case, called first. And I think he said you invented it, not critically.
It is a convenient shorthand.
Well, it's convenient shorthand for what? Because the judge wasn't just talking about the vocabulary. He was saying that the distinction between first and second level leveraging is simply not one that is acknowledged in the industry.
Yes, but my lord, with respect, what we're looking at here is whether or not Blossom was an authorized investment.
Well, that only matters if you are right in saying that it was an investment and not an administrative step.
Yes. So I need to show it was an investment, and then I need to show that it was an unauthorized investment, and that matters. And the economic equivalence argument comes at that stage of the argument. Does it matter? And it matters in this case very significantly. And so yes, whilst the labels are mere conveniences, the fundamental question is Blossom an investment? Was it authorised? And if it was an unauthorised investment, does that matter or not? And those are the issues that I really have to address before the board. So we say that the purchase of shares in Blossom was not a mere administrative step. It was an investment. It was the purchase of shares in a fund. And indeed, it is right to say, and I take no pleading point on this, but it is right to say that my learned friends, in their defence, pleaded initially in the alternative that it was an Investcorp hedge fund product, or alternatively an administrative step. But later on in their pleading, they did plead more specifically that Blossom was an Investcorp hedge fund, and in a pregnant negative denied it wasn't a hedge fund, and pleaded that it was a fund of funds. The references in the pleadings, just very quickly, are found in paragraph 72G, 75, 165, 173 and 191 of the amended defence.
And that all arose in the course of the Court of Appeal here?
No, that was their original pleading.
Was their original?
Their original pleading, they pleaded initially alternatively. Okay. It was a hedge fund product or administrative step, but later on in the pleading, they then pleaded specifically that it was a hedge fund. And there is reference to Professor Stoll's evidence, and Professor Stoll described Blossom in a rather bewildering number of ways. He not all consistent either. He said it was a customized hedge fund product, a customized SPV, sharing features and achieving effects economically equivalent to structures commonly used in the hedge fund industry, a feeder fund in a feeder master structure, a fund of funds, analogous to a customized feeder fund, a leverage vehicle investing in funds, a leverage fund of funds, analogous to a customized leverage vehicle. So actually it's quite difficult to identify which one of those he was relying upon. But what we do say is when you look at Clause A, and coming to the question that I say is my first question, Clause A makes no reference to constructing a leverage portfolio, but to the establishment of an investment account. The only reference to a special purpose vehicle is Charlotte itself. The investment manager was permitted to cause Charlotte to invest in Investcorp hedge funds or hedge fund products. It wasn't a completely unlimited power in our submission. And so the question is whether Blossom falls within the definition in Clause A of an Investcorp hedge fund, including Investcorp hedge fund product.
Which point are you on at the moment, Mr. Black? I'm sorry, I know I'm a bit slow, I'm lost.
No, sorry.
Are you on whether it's an investment at all, or are you on whether it's an investment in an authorised fund according to whatever the language is of Clause A?
The points are the same in my respect.
Are they?
I would respectfully say so, my lord, because obviously the judge in the Court of Appeal said it wasn't an investment at all.
Right.
I say...
Well, can we deal with, would it be inconvenient to deal with that first?
Yes, oh no, absolutely not, absolutely so.
And if it's not an investment, then a clause like Clause A, which determines what kind of investments they are to invest in, is not relevant.
Yes. My lord, I do say it's an investment. It's an investment for these reasons. Mm-hmm. First of all, clearly it is a separate corporate entity.
Yep.
It is audited as a fund. It is...
That's when? Sometime in 2009?
That was in 2009.
Yeah.
Actually, if you're...
It's attached to your case, isn't it?
Well, my lord...
Auditor's report.
If you give me... If I may be permitted just one moment to go through my notes, I think I can be a little more structured in this submission.
You have got a lot of ground to cover in a relatively short time.
Yes. Can I...
we are all aware that we mustn't ask so many questions as to deprive you unfairly of the time that you've got.
Can I make 5 points in answer to my Lord's question? 1, it was a separate legal entity.
Yeah.
2, Blossom invested in hedge funds as principal, not in any representative capacity. 3, Blossom entered into funding arrangements with RBS as principal. It pledged its own assets to RBS, and it was the principal borrower. In fact, Blossom could prevent RBS from assigning the White Ibis 3 to a third party. 4, White Ibis 3 imposed rules on how Blossom invested that were independent of the SPA, so it had its own investment rules and criteria. And then fifthly, the point that I started with a moment ago, it is audited as a separate fund. So, my Lord, that is the answer, I hope.
That's very helpful, thank you.
So then I do move on, if I may, to... sorry, I had meant to deal with that before I got to Clause A, and I skipped a page of my notes. I apologise for that.
Right.
So...
I understand it, underneath all that, you say that that all goes to the point that the money which Blossom is using is not your client's money, it's its own money. And
well, my learned friends take advantage of that point because they say, well, in fact, if it is an authorised investment, then yes, it is itself authorised to borrow, and so yes, then it is acting like LDSF.
They may do or may not do, but we're here on the limited question of whether the transfer or payment of the money to Blossom is an investment.
Yes.
Yes.
And my Lord, the point that I make is that Blossom has this independent life of its own, and it is able to borrow in its own name. And so I do say that it is an investment in a fund which itself borrows as principal and charges its own assets. So perhaps I misunderstood my Lord's question. I'm sorry. So we do submit that the issue then, if it is an investment, is whether or not Blossom falls within the definition of an Investcorp hedge fund or hedge fund product. The judge, we say correctly, held that Blossom was not a hedge fund, and indeed the Court of Appeal noted in its judgment at paragraph 52, page 155 of the core bundle, that if the judge ought to have held that Charlotte invested in Blossom, as opposed to Blossom being an administrative step, he should have concluded it was a breach of Clause A, and there was a breach. So, my Lord, we do say that Blossom is not an authorised investment, and that takes us then to the question of economic equivalent that my Lord Sumption quizzed me about a moment ago, and I foreshadowed that I had seven points that I'd like to make on that. Perhaps it becomes 6, but the first and foremost, on the facts of this case, when one looks at what was done, and we say this was ignored by both the judge and the Court of Appeal, is that there is an absence of transparency. Whether intentionally or otherwise, the use of Blossom disguises the use of leverage, and that all Mr. Al-Sadik saw was the apparently unleveraged investments in various hedge funds and was unable to monitor his investment.
But you say that was a breach of the SPA.
I do.
So how does it help us construe the SPA to understand whether it permitted the use of Blossom in this way, to say that because Blossom was used in this way, it produced reduced transparency? Because I understand it, you say the other clauses of the SPA would have led to equivalent transparency if they'd been complied with.
Yes, my Lord. But, my Lord, I'm trying to address the point, which I say is a bad one, that my learned friend makes, say that there is, that it all doesn't matter because Blossom is economically equivalent, essentially, to an investment in LDSF. And what I'm saying is then it is not economically equivalent to an investment in LDSF. LDSF gives transparency. You can monitor your investment in LDSF. In Blossom, you can't.
I don't think that's what the judge meant by economically equivalent. I think he was talking about performance and returns.
My Lord, I have accepted that it is quite possible to construct mathematically, if you like, two ways of investing which produce the same result. Of course, the question that rather begs the question as to whether one is authorized and one isn't. If one isn't authorized, then it doesn't matter whether it does produce the same return. But we do say that in this case, the issue, once you have decided whether or not Blossom is an investment and whether or not Blossom is a permitted investment, we then get to the point that my own friends make that it doesn't matter because they're economically equivalent. And that's the point I'm trying to address. The second point is that Blossom exposed the investor to different risks than an investment in LDSF. And the judge recognized this. Paragraphs 6.19 to 6.20 of his judgment at page 116, he recognized that there was a loss of what might be called product isolation. And so if you invest in Blossom, which then charges all of its assets to leverage the investment in hedge funds, that is different from investing in individual hedge funds that use leverage. So, for example, if you invest in SMFCO and LDSF, and there is a catastrophic failure of SMFCO, you don't have to sell your investments in LDSF, but via Blossom you do, because it's all charged across, so the products are not isolated from each other. And the judge recognized.
I mean, in the paragraph that you've referred to in the judge's judgment, he does say that, in fact, if there'd been a secondary level leverage, as originally anticipated, the losses would have been greater. Is that right?
My Lord, that is it's a different issue that I have to come to on the issue of damage.
But is it correct? As a fact.
I dispute that as a matter of law, and it is, and it.
I understand you dispute its relevance, but the fact is acknowledged to be correct, is it?
Is it mathematically correct? It is mathematically correct.
It was stated by an expert who wasn't challenged or cross-examined, I think.
My Lord, I need to develop in some detail the arguments on losses, why we say that is a partial finding, not a total finding, and how it impacts upon the loss. But what the judge is saying, and he said it earlier, is that he found as a matter of fact that if you didn't use Blossom, he found that there would be an investment in different funds, and that if those funds were retained for a particular period, then the losses would be greater. But there are so many ifs and buts that I have to come to and show you in due course on that. So if I may come back to where I was on the submission about economic equivalence. So we make the point of product isolation, and of course, on the facts, those different risks giving rise to the, if you like, the erosion of the protection of product isolation were not known to Mr. Sadik at all, so they weren't disclosed to him.
Is the point about product isolation that Blossom borrows all from one place.
Yes, and
That's it.
all of its assets are charged.
Yeah.
So it's not the same as investing in separate hedge funds. And that, the third point I want to make is that was unknown to Mr. Al-Sadik. Fourthly, he didn't agree that his assets would be directly pledged in their entirety against borrowing for investment purposes. Fifthly, under the White Ibis facility itself, a default of another borrower or issuer under that facility could require Blossom to refinance. So even if Blossom's investments were fine, if the investments of another issuer gave rise to a termination event, then Blossom could be forced to refinance its own borrowing. Sixthly, White Ibis constrained Blossom, as I said before, in the makeup of its portfolio. So the investment manager, even if there had been an investment management agreement, was not free to balance the portfolio to meet the investor's needs, but he had to comply with what the bank required. And then seventhly, if you did wish to rebalance the portfolio, rather than when you have individual investments, you can't simply just redeem one investment and then invest in something else. You have to renegotiate the entirety of the security arrangement with RBS. So for all those reasons, we say that this idea of testing whether or not the same result actually eventuated does not work. And so, my lords, if I may, I'll move on to the question of unauthorized borrowing, which we submit the SPA does not contain any express power to borrow for investment purposes. The Court of Appeal summed up our case in a passage which we cite at paragraph 43 of our written case about Morton's Fork. If transfer is an administrative act, then it can't grant a power to borrow that isn't otherwise there. Sorry, yes, it was an argument. Sorry, it was in. Yes, sorry, if I didn't make it clear, it was an argument, not in the judgment.
We realised that.
Yeah. If the investment in Blossom, which itself has a power to borrow, that takes you back to Clause A and the question of whether it's an authorised investment. We accept, for the purpose of this argument, that there may be a third point now too. Charlotte itself may have the power to borrow under the SPA, but we do say that if it is to be argued that Charlotte has the power to borrow under the SPA, that would have to be an implied power. And we've set out in our case certain observations of the Court of Appeal about where do you find the power to borrow if you don't find it in the SPA. That's paragraph 46 of our case. Both the judge and the Court of Appeal said that there was no implication of any such term.
So that was because they considered that Clause I was limited to liquidity borrowing.
And we say that entirely, and that is the limit, we say, to the power to borrow under the SPA.
Didn't they find it in D2?
They said that they could do anything. Yes, they could do anything for the purposes of the investment.
Include borrowing.
And that takes you back to A.
That takes you back to
So
A.
if
What the
A
purpose is.
permits, is a general permission to construct a leveraged portfolio.
Well, that was the.
Whether you talk about it as an implied power to borrow, you have to borrow in order to construct a leveraged portfolio.
My Lord, the point is, what does A say? A says that you invest in Investcorp hedge funds or hedge fund products. And we say that if Blossom does not fall within that definition, as we say, then you can't find a power to borrow
But that's equivalent.
within Clause A.
That the effect of this submission is that there was no power to do the very thing that it had been agreed was to be the purpose of this.
No, with respect, that's not right, my Lord.
Could they have constructed a leveraged portfolio without borrowing?
Yes, you invest in LDSF and SMF Co.
Let them borrow.
which they borrow. You are investing in identified hedge funds which fall within Clause A, the purpose of which is to leverage investments. And that, we say, was the purpose of Clause A. And that's why it refers to Investcorp hedge funds and hedge fund products. The purpose was to invest in LDSF. And if you don't invest in LDSF, you have those problems that I've referred to before when I was addressing the question about economic equivalence. So with respect, you can do exactly what was contemplated without buying hedge funds and then leveraging them at the portfolio level. And that has the disadvantages that we say. We submit that you simply cannot find an unlimited and undisclosed power to borrow in the SPA unless it's implied. The rules and implication, of course, are well known, and in its other incarnation, this court has recently revisited the issue. There is no necessity to borrow at portfolio level to achieve the results that it is said were the purpose, because you can achieve it simply and we say in accordance with the SPA by investing in LDSF or SMFCO or similar vehicles.
We're going to come, I imagine, to this expression portfolio level, are you? At some stage, because I mean everybody has a portfolio in the next stage down the line, don't they?
Well, my lord,
Charlotte has a portfolio, in a sense, a portfolio in Blossom. Blossom has a portfolio in whatever it buys. LSDF, if you buy some of those, has a portfolio of goodness knows how many other hedge funds and special managers.
Yeah, well, my lord, I agree. I mean, my lord, again, we've tried by the use of these so-called invented terms to try and capture
just a label. Yeah.
Yes, try and capture a label. I mean, what we mean by portfolio level is clearly at the level to differentiate between Charlotte investing in identified funds like LDSF, who do have a portfolio, and their sole purpose is to leverage that portfolio in a publicized and transparent way so the investor can see and monitor his portfolio, as opposed to buying funds and then without telling the investor, in this case, it's always, particularly when it comes to damages, it's always necessary to bear in mind the information flow in this case, and then leverage those funds at that first layer or portfolio. My lord, that's the label that we've tried.
All right.
Well, you accept, as you have to, that they could have put the whole fund into LDSF.
Yes.
So that the whole fund suffered all the consequences of being pledged under something like White Ibis 3, or it might have been with some of the bank, so that all those economic supposed differences would be the same if the whole fund was put in LDSF.
Yes, my lord.
And I think all you're left with is just this transparency point, isn't it?
No, my lord, well, one says just, I mean, first of all, let's not forget the judge has found, and I come to the question, that they were in breach of...
Well, I don't forget that, but at the moment we're trying to construe the contract before anybody started to perform it, let alone breach it.
Yes.
I mean, if one's construing a contract, one starts with the assumption that both sides are going to perform it to see what it means and whether it has any implied terms.
Yes. My lord, I accept that they could have made the decision to invest 100% in LDSF.
Yeah. Or in any vehicle, provided it was a hedge fund,
yes,
the sole economic function of which was to leverage money coming in so as to be able to invest more money going out.
Yes.
So it could have had exactly the same purpose as Blossom, providing it qualified as a hedge fund.
Yes. My lord, I accept all of that. It subsequently does become important when you marry it up.
No, I understand that, but at the moment I'm trying to focus on construction.
Yes, well, my lord, absolutely accept. absolutely accept that. So, but my Lord, what we do say is that is qualitatively different from what we have called portfolio level leverage. And to allow portfolio leverage, it would be necessary to imply in the SPA a power to borrow in an unlimited amount, and indeed an undisclosed amount, as was focused upon by the Court of Appeal, again, but sadly not figuring in its judgment. And we say that whilst, yes, of course, for example, the expressio unius principle is somewhat diluted now from what might have been 100 years ago, but clause I1 specifically focuses on borrowing relationships. What does the investor see when he looks at the SPA? He sees a specific clause dealing with borrowing relationships, and he sees that only 25% of his investment is at risk, because the power is only to borrow up to 25% of the equity. He knows that, yes, you could invest in LDSF. And he knows, because he is a sophisticated investor, that LDSF itself will enter into borrowing relationships. He has the right to redeem and will cut if he doesn't like what they're doing. And maybe the answer to the point, and it's not a point of construction, I accept, is, well, if they did put it all in LDSF, and indeed there was evidence about this, then he would have said, this is too risky and too much for me. I'm going to redeem, or he might ask them to reallocate the assets. But that comes at a later stage in the analysis. So we do say that there is a use of unauthorized borrowing in this case, that when you, and you have to look at, we say you have to look at it all in its totality. And so if I may, I'll come to deceitful non-disclosure, which I think I should be able to deal with quite quickly. Because the question is...
Just before you do,
yes.
You accept also, don't you, following on my previous question, that
yeah.
Charlotte could have invested 100% in a 3x leveraged feeder fund.
Mm-hmm.
There's a label for what I described at greater length
yes.
a moment ago, and gone up to 25% on liquidity borrowing.
Yes, it could have done.
Yes.
Both of those were permitted under the SPA.
I mean, when I say and, on top.
Yes.
Yes.
Yes, that must be right. Although the question is, if you invested 100%, I hope I'm not being facetious, but if you invested 100% in one fund, you have no need for liquidity borrowing.
Trying to shift it, but yeah.
That's, liquidity borrowing probably would only arise when you're transferring.
Well, yes, you might not on day one, but you might if you then want to move your investment.
Yes, if you want to move. Yes, that is right.
Yeah.
So I suppose one could say that if you're during a redemption period, and you have a need for liquidity during a redemption period,
then you are during that period under those additional risks.
Yes, you are.
Yep.
Which is perhaps one of the reasons why any sensible investor might not wish to expose himself to those risks. Which is why in this case, this investor insisted upon monthly reporting and the right to redeem. So he was not indifferent, as my learned friends say.
Well, the finding is that he was indifferent based on his own evidence. The person who may not have been indifferent was his investment assistant.
Well, my lord, that is true.
But he himself said he couldn't care less what the report said.
but he had an investment advisor who was telling him, and he did say, his evidence he did say, which again the Court of Appeal looked at and observed during the course of argument that the judge made no finding upon, he did say that he would raise red flags.
Who was it who said that?
Mr. Al-Sadik.
Yes, I see.
And we have identified that the Court of Appeal saw that, and they asked the advocates specifically, well, did the judge make any finding on that? And of course, the judge didn't make any findings on that evidence, but sadly neither did the Court of Appeal.
Well, we're straying into causation, which is for after the short adjournment. I mean, that's a very important section of your submissions.
It is, my lord.
And I mean, we've all got in the back of our mind your client's primary case that there was a guarantee.
Yes.
And you'll have to deal with that, but not now. You're going to deal now with deceitful non-disclosure, please.
I am, my lord. And the question that arises is, what is the significance of the breach of F4, and why does it matter whether it was deceitful or not? Now, I begin, I hope, by recognizing realistically the strictures of the Bank of Ecuador case and all the law that is there referred to. We say this case falls within that exceptional area that the board recognized at paragraph 8 of its judgment in the Ecuador case, where the trial judge failed in our submission properly to take account of the material and the inherent probabilities. And we do rely in the way that Robert Goff, Lord Justice Robert Goff, as he then was in Armagas and Mundagas, cited in the board's decision in Ecuador, outlined that you look at the documents and
the problem in Ecuador was a very different one, because the problem there was that neither the judge nor the Court of Appeal had focused on the relevant questions of fact, which is not something that you can really say about the judge in this case.
I can't say that, and I have to rely, and I have to be realistic about it. I have to rely on the objective evidence of the documents, and in the way that I've taken you through this morning, and which is why I refer to what Lord Justice Robert Goff said in the Armagas and Mundagas case. My Lord, I know it's an uphill struggle, but it's one that I feel can be made in this case when one looks at the
We want you to have a go in quarter of an hour.
Okay. Well, what we've already seen is in our submission a repeated and continuing misrepresentation to Mr. Al-Sadik, both actively and by omission, that his portfolio consisted of unleveraged direct investments in the identified hedge funds, disguising, we say, the unauthorized investment in Blossom and the unauthorized borrowing, and most importantly, and this comes most important for causation, inducing him to retain his portfolio, which deprived him, we say, of at least 4 possible options at various points in time. First, to rescind the SPA ab initio on the grounds of preceding fraudulent misrepresentation, and either to recover restitution of his investment or claim damages. Secondly, to treat Investcorp's other breaches of the SPA as wrongful repudiation of the SPA and accept the same as renunciation of the contract. Thirdly, not to treat Investcorp's other breaches as a renunciation, but nevertheless instruct Investcorp to cease applying first-level leverage and roll back leverage already applied. And fourthly, to exercise his redemption rights under Clause H. The short point is that the judge held that Investcorp was in breach of Clause F4 of the SPA. The judge held that Investcorp, primarily in the person of Ms. Caronde, was guilty in deceit of deceit in drafting the investment management agreement and in issuing the letter of the 10th of March of 2009. The purpose of that deceit was to justify the use of Blossom to leverage the investment. To that end, Clause 1b was inserted in the IMA, and it was expressly relied upon in the letter of the 10th of March. The judge said that was relevant to his assessment of the credibility of the evidence of those involved in the IMA. This was principally Mr. Kironde, but it appears to, in our respectful submission, to have had no impact upon his findings. If he considered Mr. Kironde's evidence credible, notwithstanding that finding of deceit against him, he did not explain why. It's our submission that if Mr. Kironde was willing dishonestly to mislead Mr. Al-Sadik about his borrowings in 2009, why was he not dishonest in 2008 when he actively misled Mr. Zaidi and indeed Mr. Al-Sadik on a number of occasions, and perhaps most importantly in many ways, misleading Mr. Zaidi as to the true nature of Blossom when Mr. Zaidi identified Blossom and telling him it was only something to do with currency rather than disclosing the real situation. The judge based his absolution of Investcorp and Mr. Kironde on the fact that they were both ignorant about whether the SPA gave them authority to leverage the assets. Court of Appeal, again in argument, said that it was astounding that Mr. Kironde had not read the SPA. And in fact, as a matter of fact, Ms. Kironde both negotiated and drafted part of the SPA. So if I make some comments in the last 5 minutes or so on the points raised against me by my learned friends, the respondents have never explained why Mr. Kironde, on any view, misled Mr. Al-Sadik about the facts on more than one occasion. It is suggested against us that we're saying that only Mr. Kironde was dishonest, and that is patently incredible. The fact is that on this issue, the focus is on Mr. Kironde and on reporting. The judge found others to be deceitful in the preparation and the backdating of the IMA. It's said that reliance on the IMA is misplaced, but Mr. Kironde, in the context of the IMA, showed himself willing to deceive Mr. Al-Sadik about the very thing which was at the center of all this, namely the function of Blossom and the borrowing. And there was reliance on Clause 1b. We say, and in fact I finished earlier than I slightly anticipated, we say that once Mr. Al-Sadik discovered this deceit, and there was clearly a process of disclosure of information, so that by November of 2009, he rescinded ab initio, we say, by the letter that I showed you from those instructing me, as he was entitled so to do. So, my Lord, those are the submissions, subject to anything that the board might wish to ask me on the issues that I foreshadowed earlier this morning.
Well, Mr. Black, that's very convenient. It's almost 5 to 1. Would it be convenient for us to break now for the short adjournment and continue at 5 to 2?
My Lord, yes.
Then that's what we'll do.
Thank you.